Or, thank you. Beat me to it. I'll start that again. Good evening. Good afternoon. My name is Ken Krawchuk, Chair of the National Judicial Committee. We are here for the appeal of Kosin versus LNC. And I see that we only have four of the JC members present. Myself, Blay, Mike, and Rob. What is the
Mr.
sense of the
Stratton will be
committee?
here in
Shall
a
we begin
moment.
or wait for the others?
Mr. Stratton will be here in a moment.
All right. Same question. There will still be missing two others.
They're aware of it, so.
Okay. Then we will stand down until they show up. Thank you. Have we heard from Stefan or the other Rob?
He just registered and so did Mr. Kinsella, but he's saying he's having trouble getting in. So hold on a moment. I'm trying to
Okay.
help him get that resolved. Says he's registered, so that's not the problem.
Mr. Roos, it will be gone in a couple of days. I only grow it for official government pictures. My driver's license is due the end of the month.
It's a look. It is a look.
I rather liked it.
Yeah, I just like it. I figure it's going to give me a couple seconds because if they're looking for somebody with a mustache, I might get out the door before they realize it's really me. I've been doing this for about 40 years, so I'm not going to stop now. Okay. Welcome, Stefan.
Hello.
Mike, who else do we have pending?
Montoni and Stratton. Montoni has not registered. Stratton has.
Okay. Thank you. Hmm.
I'm going to pause the recording while we're waiting, just because no sense in wasting. With no sense having any dead space, you know.
Yeah. Okay. There you go. All right. Welcome back. We resumed recording. 6 out of the 7 JC members are here. We're only missing Mark Montoni, and we're hoping he's going to show up. The agenda has been previously distributed. Let me just go over it very quickly. It's going to start with the call to order, which we've already passed. Opening remarks from the chair, which we're now in the middle of. Reviewing of the ground rules, which I'll do in a moment. Uh, Identifying the representatives for the appellant and respondent. Then we have the opening arguments, 10 minutes each for the appellant and the respondent. Questions from JC members follow after that, and that will continue until it's over. The sequence of speaking of questioning, I can get it right. They was chosen before, and it runs with Messrs. Latham, Kinsella, Tarnoff, Krawchuk, Montoni, Seaback, and Stratton. If there are follow-up questions, they'll be in the same sequence until we are all done. Appellant and respondent each get 5 minutes for a closing argument. JC members are allowed one final sequence of questioning, and then we'll adjourn. In general, All JC members are not muted. They can interrupt at any time, parliamentary things or whatever. Everybody else is muted except for people recognized by me or in response to a question by one of the questioners. Agenda, I mean, we've been through this before. This is the same as before. We're not separating the questions by appellant and respondent. It just seems a little clunky to ask a question of one person and a half hour ask the same question of somebody else. And I believe that is it. Any JC members, is there anything important that I missed?
Mr. Montoni just registered. He'll be here in a moment.
All right.
He's
Then
approved. We should be able to
let's
pop in
proceed
a
along the
moment.
lines. We'll be all ready when he gets here. Let's identify the representatives from the appellant and the respondent. First, the appellants. Hey, Brittany, what's up?
Hello, I'm good.
Good. So who is going to be speaking from your side?
I am having Mimi Robson represent me.
I'm sorry, you're having who?
Mimi?
Oh, right, Amy Robson. Thank you. And how about on the respondent side?
That would be me. I'm representing the Libertarian National Committee in this.
Okay. Will there be anybody else, do you know?
Not that I know of.
Okay. Pardon me a second, I make notes. All right. I really, now Mark is on the way. I really want to wait for him.
I just approved him a minute ago, so I just waiting for him to pop in to the waiting room.
As soon as we hear his ding, we will shift to the next point on the agenda without objection. We could whistle the Jeopardy tune while we're waiting. Your stuff carried.
Anyway, let's get moving, I guess. He's okay with that.
Okay, then we shall get started. So we're starting with the opening arguments from the appellant. 10 minutes. Brittany, you or Mimi, take it away.
Okay, I think it's going to be me. So although I believe that her appeal is Ms. Kosin's appeal is very self-explanatory, I will be presenting the points of the appeal primarily in terms of the responses received by Mr. Jacobs, and will only be addressing the items in the special rule of order adopted on January 2nd regarding removal from office. There were 7 points in that special rule that was passed, and there are only 4 of those points that we're arguing. The 4 are, and I'm just doing it by the number of what they were in the special rule. Number 1, at least 14 days notice shall be given to the accused. 2, the accused rights to membership, etc. 3, number 4, the manager for the party shall be a sustaining member of the national party. And number 5, testimony and deliberations are being pending or potential litigation may be held in executive session. I will say that I noticed that Mr. Jacobs did do another appeal yesterday that I did not look at, or another response yesterday, I guess, that I didn't look at because I didn't see it until just now. So I won't be addressing that. So I'm not necessarily going to do these in order of what they were in the special order either. So the first point, I'm sorry? Oh, I thought somebody said something. So the first point that I'm going to go over is number 1, which is at least 14 days notice shall be given to the accused. The policy manual cannot unilaterally shorten notice requirements for trial in violation of due process. Mr. Jacobs seems to assert in his reference to RONR 2:16 of RONR is the final word regarding shortening of notice to the accused. However, this isn't the final word. I mean, there's a reason why there's 700 plus pages in the book. He further states that notice required by RONR is only to provide the accused the charges, trial date, and any suspension of abilities and rights. If we go to RONR 63:21, it clearly states, with reference to an appropriate date for which to set the trial, 30 days is a reasonable time to allow the accused to prepare his defense, meaning it's not just simply giving them the information, but giving them time to do what's needed to defend themselves of the charges that they are accused of. And when RONR states 30 days notice is reasonable, that seems to clearly imply that anything less than 30 days would be unreasonable. As stated in the appeal, the delegates at the 2022 convention passed a motion stating Ms. Harlow should have had full due process. Per RONR 32:32, footnote 10, it states clearly that the only portions of the required disciplinary process that can be changed during the actual trial is just the process of the trial itself, not the process leading up to the trial. But regardless, per my amicus brief, Mr. Jacobs should realize, per his own writings in Pascal's Wager and the continuing breach, that at the 2022 convention, the delegates stated that full due process was required and creating a continuing breach of bylaws. Again, per RONR or RONR, a reasonable amount of time for notice is 30 days and a lesser is unreasonable. I'm repeating that because using something less than 30 days notice could be a continuing breach of the bylaws, causing yet another LNC action to be overturned at convention. Per his logic, there is no reason to use lesser notice and run that risk. Honestly, the LNC should have just heeded the warning and voluntarily changed the notice to 30 days rather than going through this. On to number 5, the use of executive session for the trial. Although I think the appeal and subsequent responses to Mr. Jacobs has fully explained the reasons why the trial to remove an officer or at-large member should be held in open session, I will reiterate that there is nothing in the bylaws that states trials should be held in executive session. Prior to the use of executive session being placed in the bylaws, it only existed as a special rule of order in the policy manual. In the policy manual, it stated the reasons for executive sessions were, and there were several, legal matters potential, pending, or past, regulatory and compliance matters, contractual compliance, personnel matters including evaluation, compensation, hiring, or dismissal, or board self-evaluation, which I believe would be something like this, looking at some of these actions in terms of their membership on the board would be board self-evaluation. It was understood by the bylaws committee that that is in fact what board self-evaluation was, and we put this in the appeal, and it would include disciplinary actions against officers and at-large members. A discussion was had amongst the members of the bylaws committee at that time specifically regarding disciplinary actions of officers and at-large members, and it was determined that those trials should be held in open session, which is why they did not include that in the bylaw. The reason for that is because, one, it's for transparency to the membership who elected that member of the LNC, and two, it gives the opportunity for, say, if there's the appeal, for that recording to be watched of the trial by the Judicial Committee when it comes to appeal. Right now, there's no possibility to do that. What happens in closed session stays in closed session. For the bylaws, there's no recording that's done. And even if there were minutes, as Mr. Jacobs has suggested, those would just be of actions. No actions can take place in executive session. All actions have to take place in open session. So to say that that could be interpreted as possible litigation, I believe that that's just not true. The investigative report could be used for litigation. The vote in open session could be used for litigation. All of these things could. So if you're saying that this is potential litigation, just about anything is potential litigation, and therefore it shouldn't be held in closed session. So to go on from there, if a bylaw is ambiguous, it must be interpreted, if possible, in harmony with the other bylaws. The interpretation should be in accordance with the intention of the society at the time the bylaw was adopted, as far as can be determined. I think in this case, it's very clear what the intention of the bylaw was, and that was for this type of trial to be held in open session. Further, Mr. Jacobs relies heavily on the provision in R1R that holding trials in open session could open the party to litigation. I'm somewhat repeating myself, I apologize. Or a possible liable suit. This falls on its face since the vote of the potential charges must be voted on in open session. He also asserts that the investigative committee report is also open for publication. If anything, the investigative committee report and referral of charges are prior to the trial and could already open the LNC to litigation due to defamation. For that matter, prior to the referral of charges or a trial regarding violative actions, the member could initiate or threaten to initiate legal actions just by the virtue of the fact that they're being investigated. We've actually seen this recently where a certain member of, or a past member of the board, has actually threatened litigation without even an investigation having been held. The last 2 points I'm going to go over very quickly. Number 2, which was the accused's rights of membership, except as they relate to the trial, may be suspended by a 2/3 vote. The only issue with that is it says rights of membership, which is unclear. The only rights of membership is the rights of their LNC membership. This could be construed that it affects other rights of being a member of the party itself. And that can be easily changed by just simply changing the words to rights of LNC membership. And then number 4, very similarly, it says the manager for the party shall be a sustaining member of the national party. This again, it's not a manager for the party, it's a manager for the LNC. And that can also be simply changed by saying the manager for the LNC. And I'm done. That was pretty good, huh?
There you go. Thank you very much. I heard Mike say we still got 3 minutes. I guess we go back.
No, she got 30 seconds.
Oh, I thought you said 3 seconds.
Oh,
30 seconds, actually.
That's why I said I did pretty good. I made it within 3 seconds.
there you go. You must be a Toastmaster.
I've done
All right.
that, yeah.
Then that's it then? Time's up. Mike, please confirm. My one ear is blocked up. All right, thank you. All right, then we shall move on to the respondent. And Mr. JJ, that's you. You're on, sir. You got 10 minutes.
Thank you. And I want to thank this committee for rescheduling this hearing. I believe it was the correct decision. Thank you. I want to start out with a reading from Black's Law Dictionary.
What's this mess?
Naturally or probably, this is the definition of potential. Naturally or probably expected to come into existence at some time at some future time, though not currently existing. And this is in relation to the requirements for executive session. These can open the assembly up to litigation in terms of liable. The reason that this is put in Robert and has been in Robert for the last 102 years is because they say, you know what, if you do something like this, we don't care about a rule or about a right or anything like that, it can create libel. in looking at some of the materials submitted, the stuff related to the Penn State scandal. That was another example of libel. In the thing that was just the emesis that was just submitted, there was yet another example of a township, a second-class township in Pennsylvania, that where there was a situation that did occur where there was the potential for litigation based on material that was included in the minutes. This stuff is very, very serious. And this is the reason why this material was out there. That, again, has been submitted along with press reports of it. So that would be the first thing, that all of these things do relate to the potential of litigation. It doesn't have to, this isn't just, there's an outside chance of litigation. Maybe there will be something that could be litigation. I am saying here, and I'm showing evidence here, that this is actually likely to, or has a high degree of likelihood at least, of reaching the level of litigation, and to try to eliminate that as much as possible. Can't be, not everything, of course, can be eliminated. There are things in there that can't, but these two particular matters can. This only applies to two things: testimony and deliberations. Does not apply to anything else. Everything else related to this, and there is a list of it in the recent filing, would still be required to be an open session. As to the length of notice, when you all decided in the Phillies case, you decided that you would be looking at the rule as it existed. You effectively said those rules that ruling of the convention is not applicable. You did not refer back and say, oh, gee, they ruled a particular way, so now we have to follow it. In fact, they did not rule a particular way. How do I know this? I'm actually the guy who wrote the point of order and came up with a suggestion. That was my role at that particular convention. So yeah, I can say that very clearly is not a requirement for notice. We know that this was not a decision of the assembly. But I'm also going to cite some other things here. I noticed Mr. Brown is here with us. I cited his most recent filing in the Harlos appeal. And he said, when talking about some ruling in the Harlos appeal, or in talking about that, he said, that might have been a cause for removal from office then, but it is not the case for removal now. The rules changed with the adoption of the policy manual amendment in 2022. That rule at the convention, whatever it was, whatever Ms. Robeson wants to claim it is been changed. And you all have recognized that change in the Phillies decision and in the Harlos appeal. We will go down to the third question, where I actually did mention, or to the third point, where I actually did mention Ms. Robson. We heard from somebody that I believe she knows that she's used as a parliamentarian, Josh Martin, and we asked him a question a few weeks ago about the possibility of a special rule, which this is, establishing a bylaw or establishing a different notice requirement. We did this with a number of things. It's attached in the filing. And we gave a list of things, including changing the changing the period of time for the notice requirement. In fact, even saying you don't have to send out a notice, you just have to say it at the meeting. He looked at all of those things and said, yeah, you can do those things with a special rule. So that would be covered in that particular issue. That's all documented in that third filing that you all got yesterday. The other 2 points, let me just go down here and take a look at it. The rule here about being the manager for the party, if you take a look at the bylaws, let me just get you the article citation here. Article 6.1 and Article 6.5 actually refer to things such as the officers of the party. The secretary shall be the recording officer of the party. That's in Article 6.5. That's stylistically just how the bylaws refer to somebody who is doing something within the party. The last point, well, there are another 2 points. The last point would be the suspension of rights. Actually, this has been published in a peer-reviewed journal on parliamentary procedure about how somebody would be removed from the Libertarian Party membership, and it does not involve the LNC at all. In fact, one of the people asking the question is a current member of the Judicial Committee. I don't think it's improper for him to ask that question. I think it's a good question, but that answer is actually there. No, this can clearly not involve member rights. As a final point, there was a question of unclean hands. That the committee report should not have been adopted. And this, as noted, it was actually adopted by the LNC, and the committee report itself had to be adopted by the committee. Both of those things fall under have to be released under 715 of the bylaws. This rule does not change that at all. There's a list of things that are actually not covered by this rule that would be required to be an executive session under Robert. The appointment of the investigatory committee and the target of the investigation is not covered under this rule, nor is the report of the investigatory committee, inclusive of any charges. The adoption and any adopted charges and specifications, any suspension prior to a trial, a vote on the innocence or guilt on every specification and charge, and a vote on a penalty. Those 2 things are technically different. This rule doesn't affect any of them. It has a very, very limited scope. And that is the sole reason for that rule to limit that scope as much as it possibly can to help prevent the possibility of litigation. That is currently all that I have.
All right. Then we move from here into JC questioning, and I'm looking at the sequence. And Rob Latham, you are first, sir. What kind of questions you got for us?
All right, first, so Mr. Jacobs, I was looking for someone else on the LNC who may be able to answer this question. Well, Ms. Harlos is in the audience, maybe, but I guess I'll give you the first crack. Question come up in my mind is, does the LNC intend to enforce this challenged language in its policy manual?
I can at least partially answer that, because the language as such, at least as it relates to the executive session, is optional. It says that they may enforce it. I don't know if they would enforce it. If it was very unlikely that there would be litigation, they may choose not to enforce it. I've tried to come up with some scenarios relating to that, but I don't know if anybody can actually answer that question until it happens, including Ms. Harlos.
And I guess the one I'm particularly focused on is the lower standard, right? Getting rid of the gross misconduct. Like, do we know if the LNC intends to, going forward from the date that was adopted, enforce that standard?
My guess would be probably, because this committee was adopted this rule was done in effect, was invoked in regard to Ms. McCardle, and from everything that I've seen, which has just been public, that would not reach the gross misconduct requirement. I think if that rule were still in effect, you could not have had any action against her.
Okay. Let me maybe pose that same question then, and Mr. Chairman, I think we're allowing ourselves to go back and forth, right?
Correct. You can ask anybody any questions. There's no point in splitting it up any other way.
Just that, although this is really not maybe, just Ms. Robson, do you have any understanding whether the LNC intends to enforce the language that has been challenged in the Kosin appeal in the policy manual?
I have no information as to what they might or might not do.
Okay. Then So the second question, I'll pose it to you first, then I'll go to Mr. Jacobs. So if this judicial committee granted the relief that Ms. Kosin is seeking, why would a separate challenge? So let's say somebody came and said, you know, the language that was adopted all the way back on July 31st, 2022, that had the gross misconduct language in it. Why should this judicial committee treat an appeal of that language any differently than it would this language?
I'm not quite sure I understand the question, but if I think that if you grant relief in this particular appeal, that would then set it back. Well, you could do one of two things. Being that it's all one special rule of order, if you decide to say that the entire special rule of order, because it's not split up, it wasn't done separately, it wasn't done as, you know, separate questions, that would make that special rule of order moot, which would then reopen up Ms. Kosin's original appeal, which was to go back to the language of July 2022. If you do just the independent sections, if you somehow just rule on just the 4 sections that we're talking about that are violative, then it could be then appealed again to go back to the language of 2022. I can't say that it wouldn't, because I think that the gross misconduct rule should be addressed, if that answers your question.
Well, maybe let's, when you say you believe the gross misconduct language should be addressed, tell me more about that. What does that mean, that it should be addressed?
Well, I believe that what was passed was what the delegates at the 2022 convention were essentially saying, is that, you know, you have to have this process. It has to be gross malfeasance, gross misconduct, and so forth. And Mr. Jacobs mentioned that he wrote that particular thing that happened at 2022. He may have written it, except for my understanding at the time it was voted on was not what he's saying. My understanding was that the delegates wanted full due process and wanted these things. But I believe that what should happen ultimately is that it goes back to the language of the 2022, the language that happened after the convention in 2022, that includes gross misconduct and all of the provisions that were put in place at that time.
Okay.
But that's
thanks.
not this appeal.
No, it's not. Again, I'm just trying to find some distinguishing principle that, you know, again, say this committee decides that this latest language, are we saying it was adopted like what, January 2nd? If we say this language violates the bylaws, then why doesn't the July 31st, 2022 language violate the bylaws? So I'm just trying to figure out what's our distinguishing principle between the two. So I maybe give you one more crack at it. And I think you've done a pretty good job just giving an answer. So I don't want to put you on the spot. If not, I'll kick it over to Mr. Jacobs unless you want to add anything more right now. No?
No,
Okay.
no.
Mr. Jacobs, what say you?
Thank you. Well, what I would say is that if you were to adopt her argument, you would be in effect voiding the Phillies decision and the Harlow's decision, because both of those were based on a rule that was not adopted at the as point of order that was not adjudicated at the 2022 convention. There was nothing in the 2022 convention about gross misconduct. That was a construct in July of 2022, after the convention. So that basically you would be in a situation where you would be reversing those two decisions. I think they would have to be regarded as being reversed. I obviously don't think that is the case here. We're not asking for those reversals. We're not asking for it to be returned to the way it was at the Reno reset. We're asking for it to basically be continuing on as it is now. This is an attempt to get the rule that you like, not the rule that was actually there in sequence. Another matter is, yes, I actually did write the language of the point of order. Yes, I developed the philosophy behind it, and I sat down and wrote the language and gave it to Mr. Elwood, and he made the point of order. This was discussed with the group prior to the meeting. I was working at the time as the parliamentary consultant for the Mises Caucus, and it was discussed with them at that point, and this was all outlined in that. So no, there was no gross misconduct at that. There was no gross misconduct claim at that convention. This thing occurred in January or in July of 2022, and wasn't in the policy manual until I think October of 2022. I did look that up.
Okay. And then this is probably getting a little in the weeds, but I'll just throw it out there. Maybe you can be thinking about it as you engage with other folks. And just this goes back to this old issue of, can the policy manual address the issue of what meets the cause standard without violating, the bylaws? And I just, I think I've written in a prior decision, I don't think that's been adequately briefed or argued yet. And I will say, just as a former bylaws committee member, I did favor a bylaws amendment to bring the gross, I guess, malfeasance standard into the bylaws. But of course, there's a difference. If it's not in the bylaws, it's not in the bylaws. It's just in the policy manual. And then, that can, of course, be changed. I don't know, Ms. Robson, if you want to speak to this just question of, can a policy manual standard of conduct be different than what is already in the bylaws?
I would like to ask if I can have Ms. Harless actually answer that.
I don't have any objection to it. Does anybody else?
No, go for it. I'm pretty easygoing as far as chairmanship. So,
Okay.
Thank you. I want to be clear, I'm not speaking for the LNC because I actually agree with Ms. Kosin on this appeal, though I may say something that's just as my personal opinion as an LNC member, but I do not speak for the LNC. But one thing I can say is I do think, and I realize he might just be saying his personal opinion, that Mr. Jacobs has gone a bit far afield. I do not believe the LNC has authorized or made any kind of decision that ruling in Ms. Kosin's case would void any prior decisions. I think he's going beyond his authority there, and I'm just speaking as an individual LNC member. That would obviously be up to the LNC chair and not up to me. However, this whole issue of cause has nothing to do with the Kosin appeal. I too was very instrumental or on the insider of dealing with that point of order as the subject person at that convention. And I do not agree with everything Mr. Jacobs stated, but I don't think it's relevant to what's stated here. Nothing here is about cause. But I will give Mr. Latham his answer as to what differentiates these two things. The cause issue was never dealt with by the 2022 convention. It was a completely tangential issue. The issue was that a trial wasn't given. The 2022 convention, for all the point of order could have meant, is I could have been properly removed, that the cause was in fact there, but I didn't get a trial. All the 2022 convention dealt with was the process, not the standard of proof whatsoever. So that is going on such a complete tangent from what this appeal is about. And I believe Mr. Brown's opinions in my last appeal showed that the LNC can indeed grant greater protections, which is within the spirit of the 2022 convention, by narrowing cause. That grants greater protection. By narrowing or shortening the notice period, you are removing protections. That is the operative distinction here, and why one policy manual change is completely proper because it granted greater protection to the person elected by the delegates at convention, whereas this policy manual amendment grants lesser protection to the people elected by the delegates at convention. And that's the operative decision. And I'll just also note here that because I have to say, as an LNC member, I am deeply disturbed by Mr. Jacobs' comments about voiding past decisions. The JC has no authority to void past decisions. Future JCs can choose not to follow it, but that should never have been said. And I will just say that I believe he just probably, in the moment you say things and, you're going to say things you weren't necessarily given authority to say because you're just speaking in the moment. I'm not imputing any kind of bad motive whatsoever, but I don't believe that's the LNC's position. But I hope I answered your question, Mr. Latham. I'd be more than glad to answer any follow-ups.
Well, and I appreciate the discussion. Actually, in looking at the appeal, I may well be, I'm now seeing procedural stuff. I'm not even seeing, oh, it just says for cause. Okay.
Yeah, that's not being challenged.
Yeah. So that's maybe even in the other appeal.
Yeah, if I can clarify, Mr. Latham, if this appeal is granted and that language is entirely struck, then it gets back to the December anything goes language, and Ms. Kosin had an appeal that she withdrew, that she, from what I understand, plans on resubmitting. And then your points will all become relevant in a different appeal. But this one, the major issues really are the executive session and the shortening of the notice requirement. Nothing about cause is being dealt with here.
Okay. Nope. I appreciate that. These are a little tough to keep straight. And I'll just throw out for what it's worth. I mean, our Mr. Krawchuk can cover his ears here. This is me being a lawyer. We do see decisions that seemed like good law at the time. A statute gets changed, and then that makes all the prior decisions based on an old statute moot, and we just go forward with the new statute and whatnot. And I think that's where Mr. Brown's opinion came in. He said, what I may have said in the old situation doesn't apply because we now have a new rule, and we got to base our analysis on the new rule. I think, I don't know, Mr. Jacobs, if I went to you on that second question that
You
I
did
put
not.
to Ms. Robson, so I want to give you an opportunity to
Thank you.
speak to that.
Thank you. Yes, I was referring to Ms. Robson's argument that the decision has to be made on that this was the decision of the convention in 2022. It was not. And it was not to have this policy one way or the other state that gross, I believe it was gross malfeasance, would be required to remove somebody. That was not handled at that. That was not part of that convention. You have ruled twice that you needed, that the LNC did have the ability to adopt the rule, that rule was in force, and that rule should be followed. Now, this doesn't have anything to do with that particular rule. That rule is not there, but nobody is challenging that particular ground for removal. It has just reverted back to cause. And the answers here are nothing in the filings have said, oh, well, this has to be gross malfeasance. There was apparently the interpretation, I don't want to put too many words in Ms. Robson's mouth, but that the convention said something about gross malfeasance. It did not. Thank you.
Okay.
Can I
Mr.
just
Chairman?
really quickly,
Oh, go ahead.
may I just follow up really quickly? So I think that there's a confusion here, probably on my part, of what I was saying that the convention did, because this appeal is not about cause. So it may have been misinterpreted, and because of what Mr. Jacobs just said, I think, at least if nothing else, I might have misspoken. But what I was talking about is full due process was what was considered at convention, and that's what the delegates voted on. I wasn't talking about the cause, because cause is not part of this appeal. So if I misspoke, or if I somehow made it sound like I was talking about cause being done at the convention, I was not, and I may have misspoke. So I'm not going to say that Mr. Jacobs is wrong in what he's saying. I said, but again, this appeal has nothing to do with cause. It doesn't. It only has to do with the 4 points that I mentioned. So
Well,
I'm just talking about notice.
yeah, although I'll say, I mean, I think an argument can be made that it is slightly about cause just because it removes the old gross malfeasance language and it just has the for cause language. But yeah, you might say this appeal is really more about process rather than standards of misconduct. So,
And again, the for cause part of it, depending on how this appeal is ruled, could come back into play with the original Kosin appeal. But that's not part of this appeal.
okay, great. Mr. Chairman, I believe, oh, Mr. Jacobs has his hand up.
Yeah, just on this, I don't believe that this really deals with cause at all. And I would note that if this would be reverted, it would still not, if you were to decide in Ms. Robson's favor at this point and revert to the previous rule, that would not deal with cause either. You would then have to go and saying that rule is incorrect. You'd have another hearing, another rule on this, and then that would revert to the rule as it was in, I believe, October 2024. And there would very likely be another hearing based on whether that rule should be in effect based on the convention in 2022. So it becomes almost like a series of nesting dolls. Trying to avoid that.
Great. Well, more to look forward to. I guess this discussion raised another just question that's I think come up for the committee. Maybe I've seen it in some of the briefing. Is there an argument about this latest rule being improperly adopted because it didn't make the threshold? Because since this committee reinstated, the secretary basically said that the suspension was void. That a voting threshold was met. Is that at all an issue here?
Are you asking me?
I guess I'll start with you since you were last person. We'll go around the horn, and I see that Ms. Harlos has her hand raised.
Okay. No, and the vote on this was, I believe, 12-0 out of out of a place where you could have a 17-member board. Ms. Harlos was suspended at the time. I think she might not have been, come to think of it. She might have been able to vote on it, but no, she was suspended at the time, come to think of it. But you did have one vacancy as well. So what you had was, even if she could have voted on it, it would have been a 16-member board, and I believe it was 12 votes in favor. So that's 3/4 of the vote. That would be sufficient.
Okay, Ms. Robson, do you want to speak to that? Or I see Ms. Harlos has her hand up if you want to defer to her or not.
I'm going to let Ms. Harlos speak to that.
Okay.
Yes, and I apologize to the JC that this can be a bit convoluted just due to the nature of the beast, but I do think Mr. Jacobs spoke incorrectly. So this particular rule that's being challenged today easily passed. There's no question about vote thresholds. This passed in January. If this were to be voided, it would go back to the December 7th language, which I think Mr. Jacobs might have gotten a bit confused about. That one, there was only an 8 yes vote, and which would have been a majority of the entire membership. I was still an LNC member. My rights as an LNC member may have been suspended, but I was still an LNC member and need to be counted in the denominator. So even if my suspension was valid, that would not have passed with a majority of the entire membership. However, my suspension was voided. So in fact, that did not properly pass in December, but that's not an issue before the JC now. If this appeal is granted, it would revert to the December language, and then Ms. Kosin's withdrawn appeal that it wasn't properly passed with enough of a vote threshold would come into effect. And that's it. That's the end of the nesting. There's no further nesting beyond that. There was nothing in October. Nobody is challenging the cause language. So you're talking about perhaps a two-stepper if you grant the appeal today. But the fact that it could cause a domino effect that affects member rights should never be an argument against granting an appeal or avoiding an appeal. If something is violative, it should be chased down to the very end, even if it does take a couple of hearings. Member rights do not yield to expediency.
Thank you, Ms. Harlos, and I don't see any other hands. So now I think I'm done, Mr. Chairman.
Okay, sounds good. Mr. Kinsella, you are on, sir. Have fun.
All right. There's another question I'd like to ask, but I'm going to defer to Mr. Tarnoff. I think he's going to ask it. So just a quick question for me for Ms. Robson. Where exactly does the bylaws contain a provision that prohibits the changing of the notice period to 14 days? In other words, why does it require a longer period than that, in your view?
Well, the bylaws don't actually talk about notice. This is something that's only in the policy manual. And what happened at convention was that the delegates voted that it requires full due process, which includes RLNR provisions, because it isn't mentioned in the bylaws. And so therefore, if it's full due process, Roberts is very clear that 30 days is a reasonable amount of time. Like I said, that would mean less than 30 days is an unreasonable amount of time. And so this isn't a bylaws provision. There's nothing in the bylaws that actually states the number of days. This is only in the policy manual. But because if it's not in the bylaws, it goes to our parliamentary authority, which is RLNR. That is where you would get the 30 days for full due process.
Okay. Are you maintaining that the convention somehow explicitly adopted RLNR as the way of determining what due process was, or that you're just assuming that when the convention favored due process, that they implicitly adopted RLNR standards for timing and notice?
Well, what they did was they explicitly said that what the LNC had done previously did not have full due process. They didn't make a bylaws amendment that said what due process would be, which again would then go to our parliamentary authority, which is Robert. So I believe that the delegates and I can just, it's my belief, just because I was there, that the way that it was worded is to afford full due process, which would be including the 30 days. And again, Mr. Jacobs, he wrote an article on this exact thing with Pascal's wager, saying that if you've got two options, one of them could be violative and the other wouldn't be. One could create a continuing breach, the other wouldn't. You would go with the one that wouldn't, because that would be the most prudent. And I believe that Roberts is very clear, under 30 days is not sufficient. So that's my answer to that, unless Ms. Harlos would like to add anything further.
Well, I think Ms. Harlos is not speaking for the LNC, so I'd like to hear Mr. Jacobs' response.
Okay, thank you. First of all, there was nothing in there specifically about adopting a date or adopting even the rules in Robert and requiring Robert to be the method for removing someone from office. It was to follow whatever rules were in force. And at that particular point, it was, in my opinion, and in the opinion of the majority of the delegates, it was the rule in Robert. There is nothing else that was added to that. Robert itself says, you know what? If you don't like these rules, you want to change them, you can. You can adopt a special rule of order, and you can modify the rule, which the LNC can do as a amendment to its policy manual. That is the basic key to this entire thing. They can determine that the rule will be something different. That is still part of due process. that there was nothing in this that would have, there was nothing in the point of order that would have established some other type of due process. Robert can do this. We've included material in the filings which actually show a parliamentarian that Ms. Robson has used on several occasions. They has said, yeah, you can do this by a special rule. You can do this in a number of other things, and perhaps even some more draconian things that we're not suggesting, by a special rule. That's where this entire thing is. That's it for me.
Let me ask you a follow-up on that. So if I get this, make sure I get this straight. So the argument is that the convention rejected the suspension of Harlos because she had not received adequate due process, because she had not had a trial. But your argument, you seem to imply that that didn't incorporate Roberts necessarily going forward. In other words, could the LNC tomorrow amend the policy manual to eliminate the trial provision altogether, to modify what Roberts requires, or would that violate what the convention had decided in 2022? Do you follow me?
Yes, it would not violate what the convention had to do in 2022. There is a school of thought that the trial itself could not be removed under Robert, that this is somehow required to be there in terms of the bylaws. I have not seen that particular language. So if it came down to me and I would have to make that, And by the way, this is mentioned in the filing if you take a look at the notes, where somebody else has said, you have to have a trial. Yeah. I would be of the opinion that they could modify it. I would be of the opinion that they could, say instead of 2 weeks, they could say 1 week or 2 weeks or something like that, or say notice must be at the previous regular meeting or something such as that for that, without too much of a question.
Okay, so if I get this right, your position is that before at the convention in 2022, the delegates voted to just overturn the suspension of Ms. Harlos, but they did not, by doing that, change the bylaws, even to incorporate in other words, to limit the discretion of the LNC to change the the process for a trial. In other words, the LNC could now, or let me put it this way, is your position that the LNC could now definitely reduce the time period for notice from Robert's 30 days to 15 days, as long as they didn't get rid of a trial? That
would easily be the case, yes. That would be my position. My position, not even before the convention, because I was representing, or I was not, I won't say I was representing, but I was advising Ms. Harlos on her appeal, was that they could have adopted a rule in 2021 that said, we're not going to have a trial. And that rule would have been binding. And that the LNC at the time just didn't do that. That was actually in the filings in her appeal before at least the successor to this committee, where I said that they could do that. So that is a question there. That is not something that is just tied to this particular position.
But the time period issue, you would say, is independent of the trial issue. In other words,
yes,
if you got rid of the trial requirement, that might be a problem. And if the notice period was down to 1 day, that might violate due process.
In theory, it might, but you could be into a situation where, it would really depend on the situation. It could. It's basically as long as there was a trial of some sort. We actually ran this past another parliamentarian who said, what if you make this you don't have to send out notice, you just have to give it at the meeting.
Right.
He said, yeah, that'd be okay.
But what I'm saying is, if in your view, if the LNC modified the requirements or the provisions in the policy manual to say you have to have a trial and you have to give at least 15 days notice, that those comply with due process sufficient that it doesn't violate the due process requirement that even the convention delegates wanted.
Yeah, because they never specified the due process of what the convention delegates wanted in 2022 was that the rules as they existed be followed.
Okay.
Okay? That was what they did. That was all that they did with that.
Thank you.
Stefan, you done? Okay, so we move on to Mr. Turnoff. Take it, Clay. Politely, please.
I don't have much here. I guess my first question is there any kind of assertion that the vote to adopt the policy manual amendments was procedurally invalid for any reason, including the fact that Ms. Harlos was not allowed to participate in debate? Would that be a valid objection?
Is that to me?
That would be both litigants.
Who do you want to go first?
You can go first.
Okay. Yeah, that would be that there was no problem with that. Robert, in fact, permits debate to be ended by a number of ways. You could even, for an entire meeting, adopt a rule that said, for that meeting, there shall be no debate on any motion. That is not a particular issue. This was a email vote where there wouldn't be the kind of debate that you would find at a meeting. And conceivably, Ms. Harlos could have talked to all the members of the LNC, just like I could have talked to all the members of the LNC and say, this is a good idea or this is a bad idea. In fact, I actually did talk to all of the members of the LNC as a member, and I said, I think this is a very good rule and I think you should adopt it.
So you're saying that Ms. Harlos could have participated. There was no de facto impediment to Ms. Harlos participating in debate. She could have effectively participated in debate, even though she was arguably improperly, suspended from the committee at the time.
I think there would have been ways to do it, though maybe not quite as artfully as it would be if she could have been signed into a message board and do it that way. But I also don't feel that preventing somebody from entering in debate is a sufficient reason to declare a vote null and void. It did not affect the result.
You have a citation for that?
I can get it for you.
So you think that's in Roberts?
That's actually in Robert. Yeah. Yeah.
So barring a member who's entitled to debate from debate is not a valid reason to declare a motion out of order.
No, it wouldn't be. Let me see. I think it's probably 6330. It's probably about 23-7. Let me just check a look here.
Okay. Would I see Ms. Harlow's hand, but would Ms. Robeson like to speak to this?
It's Robson, but whatever.
I'm sorry.
It's all right. We're not saying that the process or the vote was invalid. We're not saying that. We're talking about specific points within what was passed, but not that they violated process in doing that. And I think Ms. Harlos may have something more to add to that, but that's not that's not what we're saying. We agree with Mr. Jacobs.
Okay, Mr. Chair, is there any objection to Ms. Harlos chiming in on this?
I have no objection. As I say, I'm pretty easygoing. I just want to get all the information out we possibly can.
Okay, then I would, due respect, ask Ms. Harlos.
Yeah, thank you, Mr. Tarnoff. Mr. Jacobs is absolutely correct on this, as counterintuitive as it may be. My vote on this would not have made a difference. And so I don't believe anyone is arguing that the January vote was invalid. That's not a part of the appeal. And under Roberts, yeah, you can deny someone the right to vote, and that may stink, and you can censure people for it or whatever, but it doesn't invalidate a vote. If Mr. Kinsella in the future wants more information on the convention issue, because I do think there was critical information left out, I'd be more than glad to give it to him. But if he's satisfied with the information he got so far, I will shut my mouth. But I just wanted to say there was some additional convention information.
Okay, I'm satisfied that there's no.
I have a citation for you.
Okay.
If you would, it would be 23-7.
Go ahead. If
23:7 would be the citation. The only thing that could be done would be to basically rescind the action if they felt that it was necessary.
So, but it would be up to the body. It's not a point of order. Okay.
Yeah.
Okay. The only other point I have is I'd like to establish among the litigants here that if a rule is enforced and that rule conflicts with the bylaws, if the application of that rule conflicts with the bylaws, that action is null and void. It can be ruled out of order. It's really has no effect. Do both litigants agree with that?
If I may, in most cases, correct. There is an exception, and you will find this in the footnote to section 1026. Would be rules that were in the nature of a rule of order. That would include something like the amount necessary to, well, I won't go into it, but in most cases, this would be the case. You might want to take a look at 23.6 A, which does have the footnote that refers to section 10:26 1 and the footnote for that section. It becomes very, very complicated very, very quickly. It's called a rule in the nature of a rule of order in the bylaws can be violated without a problem.
A rule in the nature of a rule of orders in the bylaws, a rule of order in the bylaws can violate. I'm sorry.
Okay.
Those can be suspended, right? Ordinarily, a bylaw cannot be suspended except bylaws that are in the nature of rules of orders. Is that what you're referring to?
Yes, it can be also that the rule would be sufficient, or that the violation of that rule would require a timely point of order. So it would not be something that would be a breach of a continuing nature. It gets to be very complicated. There is a relationship between that. And yes, I did write a paper on it, like I've written a paper on nearly everything else. I could get you a copy of it. It also does cite, however, case law, which was Commonwealth versus Mayor of Lancaster, I believe 1835, Pennsylvania Supreme Court. You'll forgive me, I'm doing that from memory, so.
No, that's fine.
I'll be happy to provide a link if you want. It's online. I'll be happy to provide a link for you.
So if a rule violates, if a rule conflicts with the bylaws, except for this one case, the rule is of no effect. Is that right?
That is correct.
Okay. Would that necessarily mean, therefore, that the adoption of that rule was out of order? That the adoption of that rule conflicted with the bylaws?
In my opinion, it would.
And what's the basis for that?
The basis for that would probably be it would probably be 23.6A, the same citation that I just made. 23:6, number A, or letter A. That would be something that would be null and void at the time of adoption. There is material placed on that in one of my filings, where we did go in there and we did cite it. We actually cited the history over several different versions of Robert.
So, I mean, you're speaking against your own interest here, right? And you're saying that by your adoption of a rule can violate the bylaws, can conflict with the bylaws.
No, I'm saying that I'm saying that a rule adopted that conflicts with the bylaws, with that exception that I gave you before, would be something that would be null and void. If this rule were found to be in violation of a bylaw, I would agree it can be null and void. That's been one thing that has not been where
you would agree that it can be null and void.
It would be null and void if you could show that it was a violation of the bylaws. The argument that I put forward is it isn't.
The rule would be null and void, or the act of adopting the rule would be null and void?
Well, I don't see that there would be any difference. The rule would be null and void and could be ruled out of order. The act, I really do not see a difference between the act of adopting it and the adoption of it. I don't see a procedural difference there.
Well, the analogy would be that can a legislature pass a law that is unconstitutional? Is there anything to prevent a legislature from? Is it illegal for a legislature to pass a law that's unconstitutional? I'm not sure I see.
The law itself could be voided.
It is illegal, or in violation of the bylaws, or Roberts, or especially a special rule of order, but really any rule, that how the adoption of the rule itself violates the bylaws. I could see if the rule itself may conflict with the bylaws, in which case it's of no effect. But the act of adopting the rule, I don't see any authority that says that the LNC or any committee, for that matter, cannot adopt rules that would conflict, if applied, would conflict with the with the bylaws or Roberts. So I just don't see an authority.
I'm not sure what you're asking at this point. I can say that under Robert, and I'll read it to you, a main motion that has been adopted that conflicts with the bylaws or constitution of the organization or assembly would be out of order.
Right.
It would be subject to challenge, even if it is not currently pending.
That would be an act of the society. I'm not sure the act of adopting a rule can ever conflict with the bylaws. The rule may conflict with the bylaws, but the act of adopting the rule, I'm not sure could possibly conflict with the bylaws. And I would also, from a practical standpoint, wonder if it makes more sense to, at the time that the rule actually comes into effect and is actually applied, at that point, there are all sorts of specific circumstances. Wouldn't it make more sense to be able to take all of those circumstances into account when trying to determine whether or not the act, once the rule is actually applied, now there's an act that may violate the bylaws. I'm not sure I see that just adopting a rule can ever violate the bylaws. It's an adoption of a rule. The bylaws are allowed.
can I really quickly, I agree with Mr. Jacobs. You can't adopt a rule that is in violation of the bylaws. You can't. So it's not necessarily the act, but the fact that a rule that is adopted is in violation of the bylaws, that creates a continuing breach regardless. So it doesn't have to be acted upon, like it doesn't have to wait until there's somebody that is going to be affected by the rule that's violative. The rule is violative. It conflicts. You can't pass a rule that conflicts with your bylaws. That's a continuing breach of the bylaws. Except for, I guess, in the case that he was giving of that one exception of, if it's a special rule of, if it's a bylaw in the nature of a special rule. But it seems like, and I think that, we answered this in the brief back to the JC from the questions, and I think that Mr. Jacobs and Ms. Kosin agreed that you can't adopt a special rule of order that's conflicting in the bylaws. You can't do that. That alone is a continuing breach of the bylaws.
If I may,
without having ever had to be acted on.
Yeah, if I may, once that rule is adopted is when the breach begins, and that breach would be subject to a point of order at any point during the continuance of the breach.
You're saying once the rule is adopted, you believe that you could raise a point of order before the rule is ever applied?
Yes. That may be an argument against interest, but I believe that's the correct procedural interpretation of the rule.
And that would be different from striking a rule for being in violation of the bylaws.
No, it would be basically the same. A point of order could be raised that a bylaw is not, that a rule is a violation of the bylaws, and if that point of order is ruled on favorably, and there is an appeal that is ruled on in favor of the chair, just to give that example, or in favor of doing so, that rule would be taken out of effect, even if it was never applied. Can I give you an example from an old rule?
If it's quick.
Very. There was a rule that said you could suspend people from office before you had a trial. That rule is no longer there. But if that rule were there, it could be challenged at any point when that rule would be in effect.
You mean once the rule was applied, you could challenge it?
No, even if it was never applied. Even if it was 6 months down the road and somebody looked at this and said, oh, this is wrong, you could raise a point of order that the rule is in violation of the bylaws.
Okay, but would the act of adopting the rule have been in violation of the bylaws?
I believe it would be, because it does yield something that is in violation of the bylaws. And I don't believe that there is any real disagreement here with myself and Ms. Kosin on this matter. I think we're on the same page.
Is there any foundation for the principle that the Judicial Committee can strike bylaws, can strike rules that conflict with the bylaws? Do we have the authority to strike rules?
I would say, if you're asking me, I would say in theory, yes. We're arguing that is not the case here. But I think in theory, yes, you would have that ability. That's one of the things, if you take a look at the filing, and Ms. Kosin was a little bit critical of me for doing this, I said, we don't agree that with the principle here that this is a violation of the bylaws. But if it were, you can take these actions.
Well, if I look at the section of the bylaws that grants us jurisdiction, it reads, upon appeal by 10% of the delegates credentialed at the most recent regular convention or 1% of the party sustaining members, the Judicial Committee shall consider the question of whether or not a decision of the National Committee contravenes specified sections of the bylaws. If the decision is vetoed, it shall be declared null and void. The decision is to adopt the rule. There's no, I'm not sure I see in there an authority on the part of the Judicial Committee to strike a rule. You disagree with that?
I would have to respectfully disagree with you on that. That I think that the rule, when adopted, is the action of the LNC. I know that this seems to be an argument against interest, but I believe that that is the correct interpretation of Robert.
Okay, I have no further questions.
All right. Thank you very much. And looking at the list, I am next in line. I only have a couple of questions. A lot of what I was going to ask has already been answered. Mr. Jacobs, you had mentioned, you were quoting from, well, let me start from a different point of view. Should we be taking into account Sharia law when we're making up our minds on this?
I think that would be up to, well, I would probably say no, because you're bound because you're bound by Robert, the bylaws and the policy manual.
I agree with that statement, sir. Why are you bringing up Black's Law? That's some foreign jurisdiction. Why did you?
It's Black's Law Dictionary.
Correct.
I'm just giving I'm giving the definition of what the word is, and I'm trying to do it in a way that is as favorable to the opposition.
Well, backing up, why are you talking about some foreign jurisdiction? You just said that we're only looking at party rules, Roberts, bylaws. Why are you going outside of those documents?
Well, we're also looking at the English language that all of these things are written in.
Well, you said that we shouldn't do Sharia law. Why should we do American law? What's the difference? Why is one good and the other one bad?
Well, because we're speaking English and we have to know what certain words mean things. So, A is A.
So we could do English law. We could do South African law. Is that what you're saying?
I'm saying we have to use American English. I'm saying that this has a certain meaning within American English.
Well, then why aren't you going to Webster's or Merriam or something else? Why are you going to some jurisdiction which is not part of our party rules?
Well, because the party rules are in English. And I think that was the one that I would be using.
Well, a translation of Mein Kampf is in English too. Should we go to that? I think you've got it looks like you're picking and choosing, saying, when you say we're only supposed to look at certain party rules, now you're going outside of that, saying, well, here's some, I think we can use those too, but not these over here.
Okay.
Well, it seems very, very arbitrary to me. And
well, yeah, I could.
Based on your own statement, you shouldn't be looking at any of those others.
Well, I could be using some other dictionary.
That's
but
fine.
if I were to use some other dictionary, I believe that would be that interpretation would end up being much more favorable to what my position would be. I tried to use a position that would be.
Regardless of who it's favorable to or not, going to the English language dictionary for English things is proper. Obviously, it has to be. But going to some foreign jurisdiction, whether it's Sharia law, French law, English law, American law, how can you justify that?
Well, because this is a dictionary of legal terms in English for the American English.
This is not a court of law. Why are you bringing in things that are not part of us?
Well, at some point you have to determine what the English is, and that's why I was using that one. Well, to me, that was, and I wasn't picking it. I wasn't trying to pick and choose. I could pick one that says probable, which is what Webster said, and I was trying not to do that.
So why you could bring up South African stuff. Mr. Jacobs, I think it's just very untenable for you to pick and choose who your sources are, especially when you say that we're only looking at certain things within the party rules, and then you go outside the party rules to some.
Okay.
All right. So we'll leave that there. The second thing is, and Ms. Harlow's already touched upon this, and that is your opinion of how the JC works. It seems to me to be flawed. We are not bound by any prior decision. It doesn't matter what some previous JC has said, doesn't matter what they do. And you've also said that, well, if we do it this way, it's going to nullify a prior decision. We have no authority to do that. So it sounds like you have a very basic misunderstanding of what the JC can and can't do. Why do you think we are bound by past decisions? Why do you think?
Well, I tend to think that precedent does tend to be somewhat binding, and
How-
you can reverse that precedent.
Based upon what? Why do you think it's binding? Quote me a party rule.
I can quote you, Robert,
Okay,
which
please.
does say that it is. Sure.
See, because this is what I'm trying to get down to.
Okay.
'Cause-
Let me get you a copy here. Let's see. Where is that?
Yeah, I did like your mention of, you quoted parliamentary review. Definitely that would be in order.
Okay. Yeah, I'm trying to just looking here to see where it says precedent.
Let me see if I can distract you a little more. I'm just kidding.
Okay, let's see. It does deal with custom, which would be related to that, and that would be section.
That's custom is not a JC decision. That's a one-off.
What do you mean it's not a JC decision? It's in Robert.
JC decision is not custom. That's a
Okay.
one-off thing. Something comes up, JC says, do this. Custom is something that's done all the time. Has been done that way, continues to be done that way. Again, I think you're misusing your words.
Okay. I'm looking.
If you want, that was my last question.
I can send it out to you if you'd want.
I certainly would, because
Okay.
Again, I think this is key. I think you just don't understand what it is we're allowed to do.
Okay.
Or the basis of it as well.
Okay.
All right. And let me look through my notes. And if you can come back later if you find something, you let me know.
Okay.
Oh, and just one counter to Ms. Harlow. You mentioned about how you can't go from 30 days to 14 days because that limits the ability of the individual to respond. But you said that you can do it the other way. For example, changing cause in the bylaws to only certain causes. Well, that's a limitation as well, but it's a limitation on the LNC, and I think both of them would be equally wrong. You cannot reduce either one, in my opinion. And
Well, I
do.
can answer that, Mr. Krawcheck, if you'd like.
I would love to hear it, but please keep it short.
Okay, certainly. I understand in isolation how it could seem that way, and I want to give a reference to what I think Mr. Jacobs is going to, if he would look at 2310, I think.
Yeah, that's right, man.
I could be incorrect, but I think he's referring to the persuasive element of prior points of order. That would be an analogous thing. But moving on to your question, Mr. Krawcheck, is in isolation, again, I could see how they could be analogous, but in Roberts, it does anticipate the assembly adopting specified rules for cause, whereas in Roberts, it says that the notice requirement is 30 days, which is reasonable. So it's those two things are treated differently in Roberts. So that would be my justification on that.
Okay, then it's a matter of which one you're going to give priority to. Okay, thank you.
You're welcome.
And Mr. Jacobs, did you have that reference?
Yes, well, it was 2310, and it deals with
the persuasive customs.
Yeah, 23:10, and that deals with precedent being persuasive, and that the ruling in this case it talks about the ruling of the chair, but this could be the ruling of the JC as well. That there would be a certain.
I'm sorry, is it short enough to read?
I can start.
Was that yes or no?
Okay. Precedent. The minutes include the reasons for the chair giving his or her ruling. The ruling and its rationale serve as a precedent for future reference by the chair and the assembly, unless overturned on appeal, the result of which is also recorded in the minutes and may create a contrary precedent.
Okay.
When similar issues arise in the future, precedents are persuasive in resolving them. That is, they carry weight in the absence of overriding reasons for following a different course.
Okay. What is the
They are
context?
not binding on the assembly, however.
Okay.
And the weight increases with the number of precedents. I am
Okay.
suggesting here that there were 2 precedents that said you don't have to go back and look at things as they were in 2020. You don't have to go back and look at things as they were in 2022.
Okay. I certainly understand that. But let me ask, what's the context of the Robert you're quoting?
The context is primarily the ruling of a chair.
So you're talking about inside of a meeting?
Inside of a meeting, but it would also apply to the organization as a whole. Most organizations don't have separate committees to determine these things.
Why
But
do you
where
feel-
they would, that would also apply.
Why do you feel it would apply? Why a rule for the meeting? Why are you taking it up one level higher and saying it applies also at this broader level?
Because it would apply for the entire organization.
Well, I'm asking why.
Well, because in general, the assembly acts for the entire organization.
Yeah, but it's not the assembly that's doing this.
No, but it is, you're doing this on behalf, sort of the entire organization.
On behalf, sort of. I don't know. It's still, it sounds like you're talking about the custom in a meeting. Then, or 2310 is about in a meeting, and you're expanding that to include the whole assembly, which I think is a bit of a stretch. Okay. That concludes my question. Anybody have a cross question for me? Hearing none, we move on to Mr. Montoni. Take it away, Mark.
Mr. Chair, thank you. I have no questions at this time.
All right, keep us moving along. Mr. Seebeck, always look forward to the things you have to say, sir. You are certainly a loose wheel.
I've got no questions either.
Yeah, good. Then we come down to Mr. Stratton.
I don't have much in
Sorry, I
terms of
can't hear you. Can you speak up?
Can you hear me now?
Yeah, that's better. It's a
Here, let me
volume.
see. I can turn up my mic. Is that better?
Yeah, it's much better.
Yeah, I don't have any really specific questions, but what I would like the respondents to do is if each side can give like a 30-minute breakdown of just the basic of what they think the whole point of the arguments is and what they want the JC
What's
to
this
decide on.
mess?
Apologies. My email's talking to me.
Yeah. So I would like them just to give like maybe a 30-second pitch each on just the basics of their argument and what they think the JC should decide on from each side.
I think you meant 30 seconds and not 30 minutes.
Yes, sorry. My apologies. Yes, 30 seconds. We've been here quite a while already.
Well, Mr. Chair, I'd point out that the appellant and the respondent both have 5 minutes each coming up with closing arguments. I think that would meet Mr. Stratton's request.
Well, I would like to hear something super brief, to the point, not a long drawn out thing. I want just like a 30-second kind of brief, quick, what is their basics, kind of maybe a summary of what they said here and what they'd want the JC to do about it. Mr. Jacobs, you want to start?
Okay. Basically, it is that the rule is in order. It does not violate any of the bylaws. This is permitted, and frankly, the rule works. It does preserve the rights of all of the people involved. We've seen the beginnings of the rule working in regard to the prior in regard to the committee dealing with the removal or the potential investigation, of the chair. It works. It's good. It protects everybody's rights.
All right. Thank you, Mr. Jacobs. Who wants to speak for the other side?
I'll do a 30-second.
Okay.
Basically, I think we've said everything that we need to say. We believe that it does violate due process. It does violate notice requirements. And we also believe that this should be in open session because for full transparency to the membership and also for the rights of the person that is being put on trial. I don't agree with Mr. Jacobs and his assertion that it is any more subject to litigation than the investigative committee report and the votes that are held in open meetings. So I don't understand that. And I think that it gives greater due process. And then the other two, again, are just, just extra words. Put LNC in with membership or in with manager, and that fixes that. So in a nutshell, those are the things that we're asking you to do.
Okay, so maybe I misspoke a little earlier, so I do have maybe a clarifying question. So it appears that one side is saying a trial isn't necessary and it doesn't violate due process unless a trial is necessary. And the other side is saying even without a trial, you need that time and due process notice to fight it. Is that kind of the gist of it?
I don't think either of us is saying that there's no trial required. I believe that Mr. Jacobs and Ms. Kosin are in agreement on that.
No, what I'm saying is for the due process part of it, that the due process applies to a trial. That's what I thought I heard earlier, to a trial being necessary.
No, the trial happens either way. It's whether it happens with 14-day notice or whether it happens with 30-day notice. What we're saying is that Robert is very clear that a reasonable amount of time is 30 days, which would make 14 days unreasonable. And the 30 days is there for the person who's going to be on trial to have the time to mount their defense, get their people in order, their parliamentarian or their attorney or whomever. So we're just simply, the difference is neither one of us says that there shouldn't be a trial. We're all in agreement on that. It's just how many days the person should have to prepare for said trial.
All right. I don't think I have any further questions.
All right.
Do you want me to?
Oh, sorry. Yeah, Mr. Jacobs.
Okay. Yes, as far as I know, neither one of us is saying that there wouldn't be a trial. This rule does envision a trial. I would note that that under Robert, it is not necessary to always have a trial.
Okay, maybe
but this rule does.
All right, so that's probably what I heard earlier that was kind of confusing me. Okay, yeah, I don't have any further questions. Thank you.
All right, thank you. We do have a second round of questions from the JC members before we go to closing arguments. Do any JC members wish to add any additional questions? Rob, go for it.
All right. And let me maybe put this to both, just to be thinking about it. Then I did just want to make a comment, and maybe they can reflect on that if they want to further. And just, it came up in Mr. Stratton's last. I guess my question would be, we've got this trial right. Can there be a point where the notice is so short that that trial right is illusory, right? It's like, and we're going to have a trial in 30 minutes. Get ready. Does that violate due process? So that's the question. Think about it. We'll come back to it. I did want to just maybe address, because we spent a lot of time talking about this, what I've called a ripeness concept, but can the LNC, pass a rule that violates the bylaws, but if they don't enforce it, does that mean that the rule is invalid? And I think we actually kind of teased out an important difference between ripeness, not necessarily a parliamentary doctrine, but it's kind of a judicial doctrine. There was actually this comment about the sword of Damocles, and that had actually been a phrase in my mind in thinking about this case. If it's just hanging out there, does that chill what LNC officers and at-large members, can do while they're waiting for this to be enforced or not? And just to give a contrary example, right now in Utah, we have our legislature in session. The Utah legislature is contemplating a procedural rule for the courts that would eliminate preliminary injunctions for laws that are claimed to be unconstitutional. So the legislature would be essentially saying, we get that you're challenging this law as unconstitutional, but in the meantime, we get to enforce it. You don't get to stop it by taking it to court. And so that's the extreme in the other direction, where you don't get to stop an unconstitutional law. Here, you don't get to stop a rule that violates the bylaws. And so maybe that is a difference between our setup here in the Libertarian Party. And again, it's also very unique, right? That we have this judicial committee. Most boards that follow our parliamentary authority don't have a judicial committee. And so that adds an extra degree of difficulty to how we're trying to navigate through all of this. All right. So I did just want to make other appointment. We spent a lot of time talking about this adoption of a rule that violates the bylaws, but that's a big if, right? If we decide that this proposed rule is consistent with the bylaws, then we don't need to worry about whether it's enforced or not. All right. Let me get back to my question then to both. Would there be a notice period that is so short that it makes that trial right illusory? And I guess I'll put it to Mr. Jacobs first.
Thinking about this, conceivably, there could be. Normally, you would have to adopt the charges. You would have to have an investigatory committee. That committee would have to meet with the accused, or at least offer the accused a meeting, and then report back. I think conceivably you could get something there which would be close, but it would be very, very hard to do with all of those steps. It's very, very hard to do something like that over the course of just one meeting over one afternoon or something like that. So I think as a practical matter, probably you could not get everything done in that amount of time. You do have to mail out notice. It has to go to that person's address. So that's going to take a little bit of time. Even if you were to abolish the notice, you still have to inform the person of the charges. You would have to change an awful lot before you would get to that. In theory, I think you're probably right. There could be. I would not say that 14 days were. But may I take you up on a point that you mentioned?
Please.
You mentioned the sword of Damocles. Mm-hmm. In thinking back to the trial and taking a look at everything, there was a question about executive session. And I do recall somebody saying, well, we can always challenge this because it was in executive session, and you can't hold these things in executive session. That's a good reason for this to be considered at this point. Because if you can consider this in executive session, if you can take testimony in executive session, if you can deliberate in executive session, that would be a good point. I would just shifting back a little bit to the notice requirement. I would point out that there is a shorter notice requirement for this particular committee to take things through, 7 days. Part of this reason was designed that they would have a longer period than it would be to an appeal to the JC.
Okay, thank you, Ms. Robson. Did you want to speak to this?
Well, I mean, just circling back, your question was very, very specific of what would be too short of notice. It seemed like it got kind of periphery with him. So I'm still saying that less than 30 days is an unreasonable notice period. I believe that anything less than 30 days would be too short is what we're arguing.
Okay. Thank you, Mr. Chairman. That's it for me.
All right. Mr. Kinsella, do you have any additional questions?
Yeah, just quickly follow up to what Mr. Tarnoff had asked. I just think I want to be clear that I think it's not immediately obvious to me, and I think to Mr. Tarnoff, that it seems obvious to both Mr. Jacobs and to Mr. Robson that that if the LNC adopted a rule that if enforced later would violate the bylaws, that mere adoption violates the bylaws. It seems obvious to you, but if you happen to have any authority for that, an article, precedent, I wouldn't mind seeing it, even if you send it after. That's all I'll say on that point.
Are you asking?
No, I'm if you want to send anything, or I don't think you have anything now, other than the rule that you cited. But when I hear the rule that you read to me, it didn't seem obvious that refers to the adoption of a rule as opposed to an action that violates the rules. That seems like a nonsensical distinction to you guys, apparently. But to Mr. Tarnoff and I, it doesn't seem apparent, or it doesn't seem obvious that there's no distinction.
Are you done, Stefan?
I'm done.
All right. Mr. Tarnoff, any additional questions?
Yeah, well, since both sides seem to be stipulating that that it would violate the bylaws to adopt, that the act of adopting a rule that violates, that if applied would violate the bylaws itself, violates the bylaws, then I'd like to just go through the actual, I'd hope to avoid this, but go through the actual rules for, maybe briefly. There are 4 of them. First of all, I would ask, I guess this is all for Ms. Robson. Are these rules, are any of these rules anything other than special rules of order? And if you're not, familiar with the specifics of that, I can refer to the bylaws on that. I mean, to Roberts on that. Are these special rules of order? These 7?
Yeah.
They're all special rules of order.
It's one special rule of order that was adopted in one motion that had 7 parts to it. So it's a special rule of order that was adopted and then put into the policy manual.
Okay, well, I would say that it's a set of special rules of order, but so all of these rules. It was done as one motion. It was done as one motion, so therefore it's one rule. Okay, if these are special rules of order, don't special rules of order supersede the parliamentary authority?
Yep.
Yeah, in the order in Roberts, the order is first the bylaws, then any special rules of order, then the parliamentary authority. However, in our bylaws and in Roberts, the assembly is the ultimate authority, which trumps all 3 of those other things. So because the delegates at the convention stated that for trial you need to have, you need to follow all of the proper rules for due process, what we're saying is that violates the higher authority, which is the delegates at convention. So therefore, because the delegates at convention voted that due process is required, and being that our bylaws don't have anything about due process, then that would go to Roberts. So it's not that Roberts necessarily is above special rules of order in our organization or in Roberts even. It's that the assembly at convention, the delegates, they're above all of the rest of them. And at convention, the delegates agreed that full due process is required. And the only place where due process is talked about is Roberts at that point.
Well,
that was what they were thinking. They wanted full due process, which, and I think Mr. Jacobs even agreed that at that time, it was very clear that we were talking about Chapter 20 of Roberts, which provides for the due process for a trial.
The delegates did not amend the bylaws by that decision, did they?
No, but they made clear what they felt the bylaws meant, which is that full due process is required. They interpreted them to say that is what is required, and that is what they voted on in overturning it, because they stated that the action of the LNC was a continuing breach of the bylaws because they did not give full due process. And the understanding was full due process was that's given in Chapter 20 of RLNR. So yeah, I mean, it's our position that is in fact what the delegates at the convention voted on. Was they voted on basically a point of order after the fact, stating that the action of the LNC was violative and was a continuing breach of the bylaws. which is why they were able to vote on it at the time.
With
of
no
the
due
convention.
process. But are you contending that the delegates have found that the precise text of Rule 20 was incorporated specifically into the bylaws, that the precise text of Rule 20 is in the bylaws? As if the actual text of Rule 20 of Section 20, what's it called? Not section, Chapter 20, right? Chapter. That the precise text of Chapter 20 of Roberts could be considered as part of the bylaws.
Yeah, the procedure that's laid out in Chapter 20, which is that of the investigative committee, referral of charges, notice of trial, the proper notice of trial, and then a trial be held. Prior to that, the LNC had, at the time of the initial suspension, the LNC had interpreted the bylaws to say that because it didn't have anything in the bylaws at all about discipline, or because the bylaws did have something about discipline, that negated the use of Chapter 20. That's what the LNC in 2021 decided. They decided that because in their bylaws, it just takes a motion be made and no trial requirements, that is all that's required. At the convention in 2022, the delegates made a point of order after the fact, because of the continuing breach, stating that no, it doesn't matter that the bylaws have the provisions that they have. Chapter 20 still needs to be followed, that those procedures still need to be followed. And I believe that was definitely the interpretation of the delegates that voted at that convention, is that the procedure in Chapter 20 needs to be followed, which includes sufficient notice. I think that is, and again, the delegates at convention are the higher authority than the LNC, the bylaws, or anything else. They're the ultimate authority, and they voted at that time.
They are not higher than the convention is not higher than the bylaws.
Well, okay, I agree with you there. I misspoke.
Yeah.
But their interpretation of the bylaws is that it required full due process. That was their interpretation, and so they are the ultimate authority on what the bylaws mean. And what the bylaws meant to them was that it required full due process for Chapter 20.
Well, they found that Chapter 20 should have been applied. That because the bylaws do not have disciplinary procedures, that Chapter 20 applies, right?
Yeah, and each society determines the meaning of their bylaws. So the delegates at that convention, they were interpreting the meaning of the bylaws to say that in fact full due process per our parliamentary authority needed to be followed.
So would you say that Chapter 20 is word for word included in the bylaws? That was what they determined?
I would say that they determined that the due process requirements of Chapter 20 were required. As far as word for word, I think that there are certain words like a vague definition of for cause. If it's something that's more for members' rights, would require a more definitive definition for cause, that a special rule of order can be made that makes it more difficult to do something, but not to make it easier. So in this particular appeal, what we're saying is that if you go with a lesser than 30-day notice, you're making it easier to violate due process, right? You're making it easier to do something that's violative of the person that is going to be on trial. However, if
30 days,
20,
that 30-day provision is a rule of order, correct?
I'm sorry?
The 30-day provision is a rule of order, right?
The 30 days is what's in Roberts. That's in Roberts. It says that a reasonable amount of time is 30 days, and therefore less than 30 days would be unreasonable.
So
right
why
now, the
can't
special rule of order says
special rule of order that overrides that?
A special rule of order that gives greater protection could override it. For instance,
well, that wouldn't be overriding it.
If
that
it said 45 days.
If it made a longer period of time, that wouldn't override it. That wouldn't conflict with it. It would just,
right.
Be
not
in conflict.
You could make it longer, but if you make it shorter, I'm just, and this is, and I'm arguing our position, and it's ultimately up to you. And I thank the Judicial Committee for hearing this case. It is ultimately up to you. I understand that. However, our argument is that the delegates at the convention stated in their point of order that the LNC violated the bylaws by not following the provisions of Chapter 20.
You think the 30-day provision is in the bylaws, basically, right? It can't be. You're saying the 30-day provision cannot be changed to a 14-day provision, for example, because the 30-day provision is in the bylaws. You
as
would hold,
interpreted by the delegates at the 2022.
Would hold that the delegates have determined that the 30-day provision is in the bylaws.
That is my belief, yes.
That's your belief. That could that be suspended by vote? Could that rule be suspended? I mean, these would be rules that are in the bylaws that are in the nature of rules of order. So they could be suspended, right?
I don't believe that this is in that nature. I believe that this is not in that nature. I believe that it's there for a purpose of members' rights. So no, I don't believe
some of the rules that are in Roberts are not rules of order.
No, they're not. It's the parliamentary authority, but again, in this particular case, you can't suspend over the objection of one person. For right there, you can't suspend it even if it's unanimous, because of the fact that this is what the delegates of the 2022 convention determined was how our bylaws should be interpreted. So therefore, it's a bylaw. It's not a special rule of order. You can do something more, like I said, you can more greatly define cause, or you could say that it's 40 days, but you can't do something lesser that would basically go against full due process, as the delegates had determined it at 2022 convention. I think that, if you don't mind, I'm kind of, I think, repeating myself at this point. Ms. Harlos has her hand up. She may have something that maybe can make it more understandable. Maybe I'm just not being understood.
Mr. Tarnoff, would you take Karen Ann's question?
Sure.
Thank you.
Mr. Tarnoff, I believe the argument is that, not that I wouldn't say it puts those things into the bylaws, but it's certainly entailed by the bylaws. And what I think is the missing piece here is exactly how the delegates came to that conclusion, or at least the argument that was going around, which were the arguments that were made in my 2021 appeal. And that is that portion of Roberts was entailed by the bylaws because of the description of the terms of office of the officers. Because Roberts says when the terms of office are described one way, no trial is required. If they're described another way, a trial is required. Ours are described in a way that a trial is required. So it came in through the provision of the terms of office. Then when you go to those sections of Roberts, some things it leaves up to the assembly to be able to modify, such as the procedure during the trial. There's some flexibility there on how the trial will actually proceed. There is also flexibility that the assembly can adopt certain causes for removal. Where there is not flexibility is what is considered reasonable notice. And that is, in fact, the 30 days. And even if you were to consider that a special rule of order, generally rules of order can be suspended by a 2/3 vote, but a rule of order cannot be suspended when it is intended to protect a lesser minority of 1/3. In this case, it's intended to protect the accused, one person. It cannot be suspended in the face of a negative vote of at least one person. And an accused and the LNC, if they just wanted to get it over with without a policy manual, could both agree to 14 days and, put that in writing, and then they'll just, an accused can waive their rights. So even if you want to consider a special rule of order, it cannot be waived by anyone in the face of objection of at least one person.
There is somewhere in Roberts, I'm looking for it, I can't find it, where it says that rules of order can be put in, that a body may adopt special rules of order to supersede anything in the parliamentary authority, unless the parliamentary authority says that it needs a bylaws provision to supersede it. Is there any contention that any of these rules that are being adopted can't be amended because the parliamentary authority, Roberts, says that there has to be a bylaw in order to do so? That it would have to change the bylaws.
Yeah, in a roundabout way, yes, because again, this came in through the terms of office. So it starts with a bylaw. The bylaw then entails the trial requirements in Roberts. And Roberts has a footnote that says which of these requirements can be amended by a special rule of order as long as they apply to all trials and not just one particular one. This is briefed pretty fully in one of Kosin's briefs. It gets into this entire argument as to whether a special rule of order can shorten the 30 days. Now, whether or not the JC finds that argument persuasive, I would say the best way to assess it is in the writings, because, doing things verbally is a lot less precise, but it is, I could look up which of the filings it is, but it is briefed in one of Kosin's filings.
All right. Do any of these rules violate anything within the four corners of the bylaws? Not Roberts, right? The 14-day notice, for example, conflicts with Roberts. It doesn't directly conflict with anything written in the bylaws. I guess you would say the executive session may conflict with the bylaws, right? Because the bylaws require executive session, prohibit executive session, require open meetings, arguably for disciplinary procedures, right?
Yes, Mr. Turnoff. But but the bylaws also require Roberts. And in adopting Roberts, and then in describing the terms of office and the way that they do, that is why a trial is required, which is why the provisions for a trial are entailed by that terms of office provision. And
Well, I think the parliamentary authority requires a trial. You can't, you'd have to change the bylaws to avoid a trial, or perhaps adopt an entire set of special procedures in order to override the parliamentary authority. But
Roberts does not, in fact, though, require a trial in all circumstances. Roberts says you have to look to how the bylaws describe the terms of office, unless there's another provision in the bylaws that deals with a trial, which was the position of the past LNC. And the delegates in convention interpreted the bylaws. And under principles of interpretation, it says each society, and the society in this case is the delegates assembled in convention, interprets for itself the meaning of its bylaws. And in interpreting it in context in 2022, it was the due process provisions that were brought in by the way the terms of office are described.
okay, I just want to ask one more time, are any of these other four, besides the executive session, are any of the other provisions in here, do they violate or do they conflict with anything in the bylaws? Not within Roberts. I understand that the bylaws have incorporated Roberts by reference, but
yes,
do any of these other provisions, other than the executive session, rule number 5 here that was adopted, do any of the others violate anything specifically in the bylaws, not in Roberts?
Yes, potentially. It all depends upon interpretation, and I think everyone should want things to be clear. I agree with Mr. Jacobs that these could certainly be interpreted as not violative. But when it says rights of membership, all of us here may understand what it means, but a future LNC or future JC or future membership may not understand. So if that rights of membership is wrongly interpreted to be rights of party membership, yes, it violates the bylaws because the LNC doesn't have the authority to impact rights of party membership. They certainly have the authority to impact rights of LNC membership. Further, the delegates delegated to the LNC their removal power. So the trial manager is not for the party. The trial manager is for the LNC. The LNC does not have the authority to appoint a trial manager for the party. But those two are very simple fixes by the LNC. And depending upon what happens with the JC decision here today, I would say the two weighty ones are the ones you brought up, Mr. Tarnoff. And I think the LNC would, if in the future would probably end up correcting those two, even with just a recommendation from the JC, as they've made recommendations in the past. Those two hinge upon potential bad interpretations. They can be interpreted in non-bad ways. They're just very, very ambiguous.
So you're saying that number 4 conflicts with the bylaws?
Could you please read number 4 to me? I wasn't prepared.
The manager of the party shall be a sustaining member of the National Libertarian Party.
Yeah,
the bylaws, Article 4.4. Does that conflict with the bylaws?
Yes, because it's not the party that's removing the officer. So the trial is a trial of the LNC, not the party. So it would be the trial manager for the LNC, not the party. In the same way, because
they should have left out the words for the party. They should just said the manager shall be a sustaining member, and that's been fine.
Or the manager for the LNC. It's the same reason, Mr. Tarnoff, that when the LNC makes a resolution, it says the Libertarian National Committee resolves that X. It doesn't say the Libertarian Party resolves as X, because only the delegates in convention can speak for the party. Same way when the executive committee makes a decision, the executive committee has power delegated to it by the LNC, but it's an executive committee decision. It's not an LNC decision. So it may seem like splitting hairs, but sometimes these things become important. But Ms. Robson spent, the least amount of time on those other two because they are the least weighty. And to be honest, if those two, I can't speak for Ms. Kosin, but if those two were the only errors, there probably wouldn't have been an appeal. There would have been just intense lobbying of the LNC to correct those two items. And I think they probably would have been open to that. As an LNC member, I'm certainly open to it. I think it's the other two that we mentioned are really the bones.
What are the other two? Could you, you're talking about the
executive session
days,
and
notice?
yes, yeah, executive session and notice.
Executive session and notice. So the others do not violate any wording in the bylaws.
Oh no, contention is that they can. It depends on how you interpret them, and that is going to be up to the JC.
Well, doesn't it depend on how they are actually applied by the JC? I mean by the LNC.
Mr. Tarnoff, I think we've gone around this bush like a million times, and I can't say anything different than anyone else has already said. No, it's as they exist on paper, and the JC is going to have to determine if these alternate interpretations could reasonably be interpreted to violate the bylaws. That is something that's left within the good judgment of the JC to determine.
Okay. Thank you. I'm done.
Thank you.
All right. I'm next in line, and Karen Ann, you just touched on exactly what I was going to ask. There's been a lot of talk here, let me get my notes out. A lot of talk here about, can the LNC pass a violative rule? I never heard the word violative before this hearing, but there it is. Can they do it? There's a confusion there of the container versus the contents. You're conflating the two. How can somebody who passes a rule whether or not that violates the bylaws? That's overstepping their authority and walking into the realm of the Judicial Committee. Only the Judicial Committee can say whether or not something is violative. Now, anybody can have an opinion, but the actual decision of that, whether it is or isn't, doesn't belong to the LNC. It belongs only to the JC. And I guess if somebody has a brief rejoinder to that, either on the appellant or the respondent, 30 seconds, I'd love to hear it.
Yeah, let me give you 30 seconds. It's not a rejoinder. It's kind of a...
You're not, sorry, you're not recognized.
I'm sorry. Oh, I'm sorry, Mr. Krawchuk.
Thank you. Respondent? Appellant?
I will. Yes, I think that under the rules, the LNC can correct its own mistake if it makes them.
Oh, that's true. They could do whatever they like, but they're not the ones who are going to say this is a violation of the bylaws.
They could.
Maybe I'm being a little bit naive here, but I think that most people in the LNC are not going to say, hey, this is bad, I'm going to pass it. No, I would bet I'll default to saying that in their heart, they believe they're doing the right thing.
They might change their minds.
They can change their minds. That's not the issue. The question is whether they can pass something that violates the bylaws. They can't say that. They don't know. They don't have the authority to do that.
I think they can make that decision by a means of a point of order, but that's just me.
Well, they can always change their mind. That's true. But anyway, Mimi, any comment on that? You're either muted. You're muted.
You're muted.
You're the first one today.
You're right. I had my phone muted by mistake because I'm on phone end. So sorry about that. Yeah. So I would say what you just said is absolutely correct. We believe that it's violative of the bylaws. We believe that what they did is in conflict with the bylaws, as you know, we've gone round and round and round on how we get there. But you're right, the JC is the ultimate authority to that violation.
Yep.
And we believe that Ms. Kosin's contention is that it does in fact violate the bylaws. Therefore, it doesn't have to be acted upon to violate the bylaws. Just the very nature of what they did is in violation of the bylaws. But it's ultimately up to your committee to determine if in fact you agree with the, with the appeal. And we believe that it is, but, the LNC honestly, the LNC could have corrected all of this themselves with making a motion to rescind something previously adopted, and it wouldn't have gotten to you, but they didn't. So now it's up to you guys.
Okay. All right. That was my last question. Mr. Montoni, any final follow-ups? Well, I'm waiting for him to respond. Mr. Seebeck, Stratton, any further comments?
Nothing from me.
So the Roberts Rule of Order, where it says 30 days is reasonable, is there a way to interpret that as being subjective? Like that's a suggestive reason from Roberts Rules of Order? Or
who are you asking?
I'm asking Mimi or even Ms. Harlos if they could see any leeway of that being a subjective to interpretation.
I don't. I see it as they're saying that is reasonable. Anything less than would be unreasonable.
Okay. Mr. Jacobs, would you like to respond to that?
Yes, I am seeing that it says very clearly that rule can be overridden by another rule, and that rule could, that rule itself could be quite reasonable. There's nothing magical about a 30-day notice.
Okay, so I would have a follow-up question there. Is there a rule that overrules that rule?
Are you asking if there is a rule that can overrule?
Do we have rule? Does the LNC or the bylaws have a rule that overrules Robert's rule? If that's a rule that can be overridden, and that's what you stated, that do we have a rule that overrides?
Well, Robert itself says that you can have a rule that can override that. Would that be sufficient?
Yes, but as we're here as a Libertarian Party, does the Libertarian Party have a rule that overrides that?
Okay. Well, within Robert 216, special rules of order supersede any rules in the parliamentary authority with which they are in conflict. And it does give a footnote that says that there are some rules that have to be in the bylaws. This is not one of those rules. It basically says the rules adopted by the Libertarian National Committee can supersede the rules in RONR, provided that they do not conflict with the bylaws.
All right, and do we have a specific rule that supersedes this?
Do you have a rule that would supersede? Yeah, you have a rule dealing with notice. It is the let's see. Yeah, it is the first part. It's the first clause in section 1.014, which is the one that we're all talking about. That rule supersedes the requirement in Robert. There's no other kind of rule out there, nothing else out there that would say, oh, you have to put that in your bylaws, or there is something else that would require that to be any place other than the rule in Robert, or other than the rule in the parliamentary authority.
All right.
Except for,
you look like you want to say something.
In my opinion, it as far as notice goes, it's up to the assembly to decide, and the assembly decided in 2022 that the provisions of Roberts, which is again 30 days is a reasonable, less than 30 days is unreasonable notice, that was left to the assembly. The assembly decided, so therefore the LNC can't override that.
Respectfully, they did not.
Okay. I'm going to go on the assumption that they did, just for the sake of argument. So even if they did at that assembly, if it's not written down in the bylaws, how is future bodies or future JCs supposed to know that's what they decided?
It's in the minutes of the convention. Right.
But the minutes of the convention from 2019, it's now to the year 2032. And the body and the JC has a they're just looking straight at the rules and what the rules say. Are they going to somehow be able to have to dig through 10 years of minutes to see what the body felt at one time? I have you read Spooner's The Unconstitutionality of Slavery? So I guess that's kind of the point I'm getting at too. He wrote there's the intention of the Constitution when it was written, but when he wrote The Unconstitutional Slavery, here's what it literally says. So when we're a governing body, sometimes we have to look at what something literally says and the bylaws, and not what the intentions were from the people who created those laws down the road.
I see what you're saying, but
yeah.
like I understand what you're saying. Although in Roberts it says that the bylaws need to be interpreted in harmony with the other bylaws, as well as, if able to, the intention of what was done to make that precedent. And so I think it would be incumbent to go back and see why it is that we've in 2032, why we're saying this. And I think
right. Well, I'm mostly
there's
saying it
records that would state that. So,
and I'm mostly saying it kind of for sake of argument to kind of try to tease out just more feelings on this. And so the other part would then a future body then be able to reinterpret it to mean something different, that doesn't really apply in the same way that we did at 22, Reno.
well, I suppose
or
the
would they
future
be
convention
bound?
could.
Yeah, would they be bound by what that convention had interpreted as?
I would say that the only body that could, decide differently than what the convention body did in 2022 would be the convention body at another convention.
Okay. Yeah, thank you. That's what I was kind of getting at. All right, thank you. Yeah, I don't have any more questions.
All right, we're back to this top of the order again. I'll just say, do any of the JC members have any additional questions?
Sorry, Mr. Chairman. Hope this is a quick one.
Go for it.
What Ms. Harlos went through her line about special rules of order cannot be waived in the objection of one person. And I guess just the question, and sorry if it's already in the briefs, but maybe it's helpful to have it on the record here, just refresh our memory. Would Ms. Harlos have objected to this rule that's being challenged by this appeal? Does she just want to state for the record that she would have objected?
No, that wasn't my point on that, Rob. Because though that I have to tell you that's a very, very interesting question. That this argument wasn't made, but I think you actually came up with an additional argument that I would have voted no. So if the JC is going, because we didn't even I'm looking at it and in all of the filings, I don't think the issue of treating it as a special rule of order, which could be suspended, was even dealt with in either side's arguments. But if we want to deal with that here, that is in fact another question, because I should have been reinstated in December. The Phillies decision voided the basis for the trial. I would not have voted. I would have been a definite no on this policy manual provision. So if the JC is inclined to treat it as a suspension of the rules, then I think you would have to get into whether it was procedurally valid. That isn't the argument anyone had originally made, but that is certainly something that the JC can take into consideration, because quite obviously, I objected in my appeal to the executive session. So I think it's pretty proven track record that I would have objected, even if it was just on those grounds. But I'm telling you, I would have objected on the notice requirements as well.
Okay, thank you. And Mr. Jacobs, I guess on behalf of the LNC, you've got your hand up. And to that
yes, this did not involve any kind of a suspension of the rules. This was a straightforward motion to amend something previously adopted. There was no suspension involved in this relating to the rules. So this would not be applicable. We would also note that the rule itself, notice, cannot be suspended because it involves basically the rights of either an individual member or of an absentee. Probably in this case, an individual member. So if there is a notice requirement, that rule could not be suspended as long as that person is either absent or does not consent to the suspension, or both. So I don't think this is applicable at all.
Okay, thank you. That's it again, Mr. Chair.
Thank you very much. Okay, JC, any further ones, or can we move on to closing arguments? Hallelujah. Hearing none. All right. For the appellant, 5 minutes closing argument. What you got?
I'm not going to use 5 minutes. I think that we've gone through this
I agree.
every which way but Sunday. And I think that, again, the two that we're talking about as far as executive session and notice, I think we've gone through that ad nauseum. I think the other two are lesser, but they are still in violation of the bylaws because they could lead to ambiguity. Yes, I can still speak. Or misunderstandings in the future as far as membership. So I think I will just really leave it at that and let the briefs and the arguments be what you guys consider. Thank you.
All right. Thank you very much. The respondent, Mr. Jacobs.
Okay, thank you. First of all, I do want to point this out that there's been a lot of discussion of the bylaws. None of these things, with one exception, is even alleged to be a violation of the bylaws directly. And that one exception is the executive session question. The executive session question deals with whether or not it is applicable under a particular set of bylaws. The argument put forward here, and the reason for it, the reason is actually stated, is that it is something that is very likely to create it is likely to be potential litigation. Not possible litigation, not an outside chance, but that there's a fairly high likelihood for litigation. And that is the requirement in there that one is based on. But the rest of these things are not violations of the bylaws. The bylaws don't say anything about previous notice. Robert says something about previous notice, but it also says, you know what, you can change that. That's where all of this stands. This is a question of, it comes down to it, which you guys get to determine what the bylaws are and whether something or not is a violation. And the one thing that is actually a claimed violation is whether or not this is potential litigation under Rule 715. Thank you.
All right. According to our agenda, we got any final comments or questions from JC members before we adjourn? Anyone? Bueller?
Actually, I do have one quick question. What about the provision in the bylaws that executive session can be used for personnel matters? Mr. Jacobs, would you? I know that wasn't in your brief, but could this be considered a personnel matter?
I think in some cases it might be able to by some people, but I believe that the way that the statute in DC is worded, it's not considered personnel. However, we have seen some cases where it did involve personnel. If we can use the Harlos removal, for example, it did include some reference to a subcontractor. That was me at the time. It can include some reference to the investigation part, which would also be part of the testimony, did include a meeting with the acting executive director. So there would be some elements that might involve personnel.
And who would determine whether or not a disciplinary trial is a personnel matter or not, or a litigation matter or not? Would that be a matter for the LNC, or would that be something that is absolute?
I would say that this is absolutely not a personnel matter. This is a board member. It's an elected official of the party that's elected by the delegates. It's not a person that's being paid. It's not a person that's under contract. It's not personnel. And I would say that, you know, going back to the original, when it got placed in the bylaws, what we had before that was a special rule of order in the policy manual that actually did say board self-evaluation, which they interpreted to mean things like disciplinary actions of a board member. And that was not put into the bylaws because they felt when they presented that bylaw that was something that should not be part of it. So I don't think that there's any way to argue that disciplinary action of a board member would be in the nature of personnel. They're not personnel, just plain and simple.
Mm-hmm. You're right. I'm trying to find some way to rectify the bylaws and Roberts, because Roberts is extremely strongly supportive of the notion that all of, you know, everything to do with disciplinary procedures should be done in executive session. You know, but apparently the bylaws have the exact opposite statement, you know, and Roberts is really warns you that, you know, you could really be opening yourself up to defamation, and it really shouldn't be done. And then the bylaws seem to say, okay, we're going to open ourselves up to defamation. So,
but again, I mean, I would just argue that
to extreme position.
The investigative report can open them up to litigation. The fact of just preferring charges could open them up for litigation. And, you know, and what I'm going to say has nothing to do with this really, except for to say that in California, for instance, in our bylaws, we're very clear that disciplinary actions of a central committee member, which we are allowed to do here, or a board member, it's up to the person that's being, you know, the trial is for, as to whether or not they want it in open or closed session. And that maybe is something that bylaws could look at in the future, but it doesn't have that. But I think it's very clear that because these are, I mean, it's kind of akin to, and not to bring in other things or other laws or other things like that, but when you have impeachment hearings, you know, in government, those are open session. But anything can lead to litigation. And again, I'd say that the investigative report and the referral of charges in open session could be worse than the trial being in open session, because at least in the trial, the accused has the opportunity to defend themselves in front of the membership that in fact elected them.
Thank you.
Well, you said it was going to be quick. All right.
Yeah, I'm done.
Thank you.
That was quick. That was quick.
Comparative. Yeah. Any other comments from any JC members? Oh, double hallelujah. With that brings us to the end of our agenda. Just one personal note. We're going to have another hearing next week for Robson versus LNC. If anybody has any suggestions, comments, or evaluations of my performance as chair, or things that you think we could do better to make these things go quicker or smoother, please get in touch with me. My email is info@kenk.org, info@kenk.org. And I'm a Toastmaster. I'm always looking to get better. I'm open to any suggestions you may have. With that, I will call this hearing to a close. Thank you all for the last 2 hours and 40 minutes of your time.
Thank you.
And enjoy the rest of your weekend.
Thank you. And thank